The Indian Penal Code, as we know it, is now history. It has been replaced with the much debated new criminal laws. I'm Barkha Dutt, you're with the Mojo Story. The new criminal laws will provide speedier justice, argues the government, arguing that this is a major reform of India's legal and judicial system. But critics have said that the laws have been passed in a hurry, in a questionable manner, and could, in fact, push India towards being, quote unquote, a police Raj. To understand what really changes for you and me, for ordinary citizens in the law, in our daily lives, in fact, because laws impact all of us, let me welcome to the program our guest on the program today, our newsmaker. Indira Jaising is with us. Indira Jaising, of course, is one of the country's foremost legal minds, one of the veterans, as it were, of the court. Thank you, ma'am, for your time. Your comment on social media, in fact, used this phrase. You said that in Nehru's time, it was, the tryst with destiny speech at the midnight hour. India woke up to independence. But in this case, at the midnight hour, India has woken up to what you call a few steps closer towards being a police Raj. Why do you use this phrase?
Yeah. Barkha, see, given my age, I'm old enough to remember the tryst with destiny speech. So it's constantly on your mind. And all laws, when they give you a date, they come into force at midnight of the chosen day. So obviously, this law came into force on midnight of 1st July. It's today in force. Now, why do I say that it ushers in what we would call a police Raj? Primarily because it does 2 or 3 things. 1, it introduces the power to handcuff people. 2, it introduces solitary confinement. 3, by the way, these were outlawed by the judiciary. 3, it increases death penalty from 11 crimes to 15 crimes, whereas the world is moving towards abolition of death penalty. And our Supreme Court is also moving in that direction, where they're narrowing down what we call the rarest of the rare cases. And here we have the legislature expanding those crimes. Apart from why death penalty doesn't work, that's another issue. But let's come to the critical issue. The critical issue is police remand now can go up to 60 days or 90 days, depending on the nature of the crime. Now, under the old dispensation, you could not have a remand for more than 15 days in police custody. Beyond 15 days, it could be judicial custody. So, look, the main thing is they've got rid of judicial oversight. The magistrate sitting there is meant to be an impartial member of the judiciary who is overlooking the work of the police. Now you're getting rid of that. So if that is not police Raj, what else is it?
Let me argue for a moment from the government's perspective. They say some things have improved. For example, we have put a finite timeline by which a judgment must be delivered once the trial is complete, and therefore they're saying this is speedier justice. 2, they have argued that we have done away with sedition. I know people like yourselves have written in the Indian Express and elsewhere that sedition has actually come back through the back door. But let's look at these 2 points that the government has actually, held out as achievements. A timeline now by which a judgment has to be delivered. They say this will vastly reduce the backlog. What do you say?
See, Barkha, there are 2 issues over here. Timelines are known to laws. They're not new. Let me give you an example. The Protection of Women from Domestic Violence Act says you must get a stop violence order within 1 week. Let me tell you, you may not get it for 1 year. So they have put timelines in this law for everything, for investigation, etc., 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 and similarly for judgments. The question is, will the Supreme Court see these as mandatory or as directory? Now, others have argued, other than me, that the timelines indicated for judgments are not long enough to enable a proper reasoned judgment in complex matters. Now, when they talk of complex matters, it could be matters relating to corporate fraud and so on and so forth. That's an issue which has been addressed by others. But the fact of the matter is that in this country, timelines have never been held to be mandatory. You take the Supreme Court of India. Do they deliver their judgments in time? They don't. Okay, though they have set timelines for themselves. So it's an illusion to think. The most important thing is your workload of the judiciary is going to increase. All institutions have
Explain that. Explain that. Why will the workload increase?
okay, it will increase because we will all be arguing on the question whether there are two parallel legal systems in this country as of now, meaning thereby anything registered or done prior to 1st July will have to continue under the old dispensation. Anything registered and continued under the new law will have to continue under the new dispensation. But the fact is that the Supreme Court has held that procedural laws can be retroactive and retrospective. So they can apply to pending proceedings. They can apply to proceedings in the past. They can apply to appeals, the new laws. And you're going to have a million disputes by accused, by the prosecution saying, no, the old law continues to apply. And some will say, no, the new law applies. In other words, we will each choose what is better for us, what is more beneficial for us. Where is the capacity in the judiciary to deal with all this? The workload, that is why I say, and in the letter which I wrote to the law minister, I made one simple demand. I didn't even talk about the substance of the laws. All I said is, have you done a judicial audit of the amount of workload that will go up by the introduction of these laws? I got no answer to that question.
Let me just understand this point. You are saying that if there is an FIR registered against me prior to 1st July 2024, then I will have to be tried by that law, and henceforth there will, any new FIR will be tried under a different set of laws, and every lawyer will then argue one way or the other depending on what they think will suit the case. And therefore, it will complicate matters. So instead of this law replacing the penal code, why hasn't it fully replaced the penal code? Because it doesn't apply retrospectively. Is that what you're saying?
That's right. It does not replace the Indian Penal Code because millions of cases are pending under the old code. Right. And see, Barkha, a substantive crime, let's say a crime of rape or a crime of robbery or a crime of assault, cannot be created retrospectively. The Constitution says that a crime has to be a crime defined in the law at the time when it is committed. So to that extent, the Constitution protects us. No newly created crime can apply to something I did before 1st July. But that is not true of procedural laws, which was the Criminal Procedure Code. So, for example, the remand, which in my opinion they can now have for 60 days or 90 days, whereas earlier they had it for 50 days, can apply to a crime which was committed before 1st of July 2024. Whether it does or doesn't is for the Supreme Court to clarify. Okay, when is that D-Day going to come? When the Supreme Court is going to clarify the thousands of ambiguities that this. And remember one thing, it's a fundamental principle of law that criminal law can never be vague. After all, you're being denied of life and liberty. So it is a fundamental principle of criminal law that it must not be vague and it must not be uncertain.
Let's come to sedition. Got this point. Let's come to sedition. This was initially when the drafts of these new laws appeared. It was, presented as the end of sedition. The end of sedition. The word is gone. You have argued that the law has not gone, and in some ways, the idea of who is anti-national has now been written into the law, which didn't exist earlier. Talk a little bit about that.
So, 124A, which was sedition, was actually stayed by the Supreme Court of India. Remember that, by a bench presided over by Justice Ramanna at that time, where the government of India agreed to the stay of that section. Now, you have introduced the same terminology in a new avatar, which is more virulent. Now, why do I say it's more virulent? 124A did not contain the words anything that is likely to impact the sovereignty and integrity of India. These words have been added to the reincarnation of sedition. Now, they did not exist before. They did exist in the law relating to terrorism, the UAPA. Now what you have it in an ordinary crime in the Indian Penal Code. Now, Barkha, I have been saying this for a very long time. Like, there is no crime known as being an quote-unquote urban Nakshal. Where is the crime? Who has defined it? Nobody. There was no crime known as anti-national. Who defined it? Nobody. And this is why I've been saying, tell me where it's a crime to be anti-national. Now, in this avatar of sedition, it says anything written or spoken which is likely to impact the sovereignty and integrity of India or integrity of India is a crime. And
now I have a question. The Supreme Court, if I'm not wrong, had concluded that unless words incite violence, there has to be an incitement to violence for words by themselves to constitute as seditious. Given that judgment, and now given this sort of language that you have just referenced, if I make a speech that is considered to be against the sovereignty of India, so for example, I'm in the Northeast. I'm a member of the Naga groups with whom the government itself has had negotiations, and I have a certain point of view that that questions, historical integration, but is not violent in any other way. Will I be considered seditious?
There are two answers to your question. The first is you made a reference to the judgments of the Supreme Court given under Section 124A, which said that you have to have a link with violence before you can call anything seditious. Now, the point is, why did they not put that in the new law? Okay, it's not there. Secondly, it's anybody's guess whether the section that has been now introduced will be interpreted in the same way by a new Supreme Court of India. It's open season. Anybody can argue, no, that was under the old law. Now we've got a new law. Now we need a new interpretation of a new law. And remember, the word sovereignty and integrity was not there in 124A. Now you've introduced it. So yes, it's fine. Let's all of us wait till we get to know whether our speech is seditious or not seditious. And the second answer, obviously, is if you know that in the past also, even when speech has not led to violence or it was not likely to lead to violence, it was always introduced along with UAPA offenses, always. This is the reason why the Supreme Court stayed that law, because of the massive abuse of the way in which the law relating to sedition was being used over the last.
But we've just seen Arundhati Roy face a UAPA charge for a speech made many years ago on Kashmir. Now, without getting into whether I agree with the speech, don't agree with the speech, I want to understand: does the UAPA run concurrent to some of these sections in the new criminal law, which talk about speech that militates against the sovereignty of India?
There are now 3 different provisions under which terrorism will run concurrent. The UAPA continues to exist, under which she has been, sanction has been given. She has not yet been charged to commence a prosecution under that law. You now also have it under the new avatar of the Indian Penal Code, and you have it in the section relation to sedition. Okay, so there are 3 different laws which talk about sovereignty and integrity of India. Now, as I said, Arundhati may not be prosecuted under the new laws because that will offend the Constitution of India. Substantive laws cannot be retroactive. But what procedure will be used to prosecute her is not something I can guess or say, the old or the new.
What about, the fact that you have spoken of the Chief Justice's, Justice Chandrachud's response to this? In fact, one of your comments on social media said the Chief Justice has taken a position. He's welcomed these laws. He, in fact, described them to be a watershed moment. What happens now? Now that the Chief Justice has taken a position on these laws that are being so fiercely debated in the public space, is that some sort of conflict of interest, or how do you see it?
It was a sad day when he made a comment welcoming these laws. First of all, it was completely unnecessary. As the Chief Justice of India, he should have known, or ought to have known, that there is going to be a challenge to these laws, and he will be called upon to decide about the constitutional validity. Barkha petitions were filed against these laws even before they came into force, and the court rejected them, saying they have not come into force. But D-Day has come now. So obviously there will be a whole new lot of petitions filed in the court, which the Chief Justice of India is going to be called upon to decide. Now, what happens once he has already welcomed these laws? Certainly it will lead to a bias in the mind of the petitioners. Look, and of course, public interest litigation is one thing, but there are real people who will go to court, who will be probably arrested, and who will say, why am I being arrested for 60 days? Why am I being arrested for 90 days instead of 15 in police custody? What happens then? They will definitely carry a bias in their minds that a person who has pronounced on these laws in the public domain is going to be biased against me. Now, it's not, as I can understand, probably the Chief Justice meant that the introduction of IT technology in the use of forensic investigation is a welcome step. But the comment was not confined to that issue. So I think it's a very serious matter.
So, I mean, he can't possibly recuse himself from all the cases that come to the Supreme Court.
Yes, that would. I mean, if there are millions of cases, he can't refuse.
It's not practical, though we don't really know his mind on these laws. He may have been making a general comment that you say he should not have made.
I do agree with you that we are not in a position to make up our minds exactly what he meant when he said what he said. But there is no way of knowing unless he's willing to have a proper debate with the legal profession. We now have Supreme Court Bar Association, a new president who can certainly approach him and request a debate on the issue. Transparency on these matters is always welcome. There is no two ways of looking at it. But when something is for sure going to be pending in a court of law, then I guess it's best for judges not to comment on it outside the courtroom.
Civil society groups have raised some concerns about the law not recognizing rape of men, of transgenders. I know you have years ago fought a long fight to decriminalize homosexuality. We moved very far on that. 377 goes, but it leaves these ambiguities as it goes. What concerns you about that?
The obvious concern is that same-sex abuse now goes without a criminal remedy. But I've been reading in the press that the law minister has made an announcement that he's going to look into this matter. The point, of course, is there are mindless inclusions and mindless exclusions from this law. And it bothers you. Why was this new law necessary at all? Now, they probably will turn around and argue, 90% of the provisions are the same. Well, if 90% of the provisions were the same, all they needed to do was to amend the old law and add a few of the provisions, particularly the ones relating to forensic investigation with the aid of technology, into the old law. They chose not to do that, and that's why the entire process has turned out to be so mindless.
One of the things that they argue is a welcome thing, and on surface it does seem to be a good development, is the concept of the zero FIR. In particular for women, for example, who have faced sexual violence, you don't have to go to the police station that is in the jurisdiction of where you were attacked. You can now file an FIR irrespective of where you are. And we saw how this was applied, for example, in Manipur. Do you welcome that or welcome any other features? And when it comes to the process of registering an FIR, that has been another contentious aspect of these new laws.
So it was the law that you could register a zero FIR anywhere by virtue of a decision of the Supreme Court of India, and we've been doing it. But yes, it is a welcome addition to a statute, which is then binding on the police. They can't say, we don't know what the Supreme Court said and what they didn't say. So yes, I agree. It is a welcome addition, but it's nothing new. It is the same thing. And I think you had one.
What changes in how the police are obliged or not obliged to register an FIR?
A lot changes. For offenses punishable between 3 to 7 years, they are not obliged to register an FIR. They can conduct what they call a preliminary inquiry, open house for corruption. Okay. This is again against the decision of the Supreme Court of India in Lalita Kumari's case. One thing which does surprise me about these laws is how easily the legislature can just get rid of judgments of the Supreme Court, which took years and years and years to achieve. The fight to ensure that an FIR is registered as soon as the complaint is made was over a period of 10 to 20 years by the time the case reached the Supreme Court of India. And with the stroke of a pen, they've got rid of it. And now they say all offenses punishable between 3 to 7 years can now undergo a preliminary inquiry, okay, which means you're stuck. And it's then within the discretion of the police to decide whether to register or not to register an offense.
What do you make of the first two cases that we know of in which the new laws have been applied? A motorcycle theft in Gwalior, a street vendor in Delhi.
So then, particularly street vendors, I have a soft corner for street vendors for various reasons. I buy a lot of my daily commodities from them ever since I did the Bombay Hawkers Union case, which was way back in 1986, where the Supreme Court declared the right to hawk a fundamental right. So what do? You pick up the poor. Who's going to be affected by these laws? The most marginalized communities, right? And if I read correctly, they've imposed a fine of 5,000. Where is a street vendor going to get 5,000 rupees to pay? For what? For something as simple as being on a street. And, this is it's an issue which is a class issue, if I may put it that way. And it's a lot of, middle class and upper class people who say, street vendors and slum dwellers and hawkers and pavement dwellers are a nuisance. So let's just remove them. And this seems to have happened in this particular case, where the only thing the person is accused of is placing some objects on the street, for which you have to pay 5,000 rupees.
Finally, as we end, what happens now? What happens? Is this now a done deal? Can there still be amendments? Of course, there can still be amendments. Move to this law. Now that the law has not been put in abeyance, as you and others had argued, there's also the questionable or the much debated process by which they were passed in Parliament when more than 100 members of opposition were suspended. But what happens now?
Look, Barkha, I'd like to preface my comment by saying that there's a sense of deep disappointment with particularly the allies of this government, because civil society made a strong appeal to them to raise this issue in Parliament. It was a simple matter of issuing a notification extending the date for implementing these laws until the new Parliament had an opportunity to look at these laws. They didn't do it. I haven't heard, correct me if I'm wrong, but I have not heard a word from the allies of this government making this request, saying that give us an opportunity to just relook at these laws. And all you need to do is issue a notification saying the effective date will be notified later. That didn't happen for me. This is the biggest disappointment that I can possibly think of. So to answer your question, what happens next? We are in a mess. That's what happens now. And I guess the ball is now in the Supreme Court of India. You've got a flurry of activity. The Bar Council of India is convening meetings. They've called all the bar associations in to have a discussion. But to what end? The new laws are upon us. That's all there is to it.
And the Chief Justice has, to some degree, taken a position on them, further confusing, in a way, the opportunity for legal recourse?
I think so. So now I think the only solution left is for the 5 senior most judges of the court to hear the case. And this might mean excluding the Chief Justice of India. It's for him to decide whether he will recuse himself from hearing this. Because
unless he comes out and elaborates on his position, because we have only one sentence from him.
Well, an elaboration will be most welcome. But Barkha, I can tell you that one of the most contentious pieces of legislation that has been put on the table is the use of electronic evidence, its admissibility and its relevance in the Indian Evidence Act, in the replacement of the Indian Evidence Act. And we all know that the Chief Justice is maybe rightly so, very keen on introducing technology into crime investigation. But look at the Bhima Koregaon case, for God's sake. Has the law dealt with remote planting of malware? It hasn't. Who is going to ensure that the electronic evidence that you collect is actually what was on my device? It's going to be one of the biggest contentious issues of these three laws, I would say, more than anything else. Many of us use devices now. A lot of crime takes place on the media. So everybody's going to say, well, this was not my device. You didn't take it in the manner prescribed by law. You don't know whose computer it's taken from. You don't know what malware.
And in the Bhima Koregaon hearings, if I remember correctly, it was Justice Chandrachud who actually was scathing about the way the police had conducted itself. If I'm not wrong.
This law makes no provision for finding out whether malware has been remotely planted or not. All those disputes will continue.
Troubling questions. We leave it there, Indira. Thank you for giving us a lot to think about. But yes, I think none of us know what happens next. The laws are upon us unless the government is persuaded to have a change of heart, unless the new opposition can make enough noise and use its numbers to at least have a proper debate in the public space, or then the final word belongs to the courts. Thank you, Indira Jaising. Yes.
One last thing. I do not understand how the names of laws can be changed simply by using Sanskrit in the Roman script. Okay, how do you change them? There are laws relating to languages in which laws are, and then what happens if every state amends the laws and says we are going to change the name to a Kannada name or a Tamil name?
So one thing about that, the government has said the states are free in some of the spaces, some of the clauses to bring their own amendments at a state level. What do you make of that?
Indeed, the states are free, but an amendment made by the state goes to the President of India, and the President of India takes a call whether the amendment is justified or not justified. You're stuck. You're back to square one.
But technically, the states can amend these new laws.
Oh, yes, they can, and I would urge all of them to amend them. To make sure that life and liberty are protected, not for any other reason. They might even want to change the names, use a Kannada name, use a Telugu name. To what end is all this? I don't understand.
We are, as you said, in for some very messy times. Thank you, Indira Jaising, very much for talking to us. Take care. See you soon.
Bye-bye.
Bye. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.